Hey guys, tonight we're stepping back in time to an era where the strangest rules governed daily life. Where logic took a long holiday. And where what you thought you knew about justice is about to be turned on its head. Picture this. You're not in your comfortable bed. No, you're in a dimly lit, drafty medieval courtroom. The air smells of damp straw and something vaguely like a wet dog. A roaring fire crackles in a massive stone hearth, casting long, dancing shadows. A stern-faced judge, robed in heavy wool, sits at a massive oak desk. And before him, a defendant. But this defendant isn't a person. It's a pig in a witness box. You probably won't survive this. Either the sheer absurdity will make your brain melt, or you'll be fined for not having the right kind of pig. So, before you get comfortable, take a moment to like the video and subscribe, but only if you genuinely enjoy what I do here. Let me know where you're listening from and what time it is, and we can all drift off together. Now, dim the lights, maybe turn on a fan for that soft background hum, and let's ease into tonight's journey together. Alright, now settle in. You're watching this pig. This isn't a joke. It's a very real legal proceeding. The pig, accused of eating a human infant, a tragically common event back then, is being represented by a real lawyer. Yes, a lawyer arguing on behalf of an accused animal. The charge is murder, and the penalty is death. It sounds utterly bizarre, doesn't it? But animal trials were a real and sometimes frequent feature of medieval European law. These wasn't just a one-off thing. Records show trials for everything from a weevil infestation to a rat colony, and even a swarm of locusts. The idea was that these creatures, as beings under God's law, could be held accountable for their actions, particularly if their actions were deemed to be malicious or, at the very least, criminal. The animal would be brought to trial. A prosecutor would present the case, and a defense attorney would try to defend a pig. The pig, of course, was silent, which I'm sure made cross-examination a breeze for the prosecution. The legal reasoning behind this was, in its own way, consistent with the religious worldview of the time. If God created everything, then everything had a place in the divine order, and that order could be disrupted by a criminal act, even if that act was committed by a brute beast. If a pig broke the law, it wasn't just a random act, it was a perversion of that order. So, you had a formal trial, with all the usual pomp and circumstance. You'd have witnesses, a jury, and a verdict. A guilty verdict often resulted in a public execution, sometimes even involving the animal being dressed in human clothes for the spectacle. Imagine a pig on the gallows, wearing a tiny little waistcoat. I mean, it's almost too much. Now, while pigs were the most common animal to be tried, because they were often a little too fond of human flesh, other creatures faced the same fate. Think of a rooster being tried for the heinous crime of laying an egg. Yes, that's right, a rooster. The egg was believed to be a cockatrice egg, and it was a sign of black magic and witchcraft, capable of unleashing a mythical beast. The rooster, found guilty of this impossible act, would be summarily executed by being burned at the stake. Historians still argue whether these trials were rooted in genuine superstition, a way for the legal system to assert its authority over nature, or a grotesque form of public entertainment. It's probably a bit of all three. These were a society's attempt to impose order on a chaotic world. A world where the lines between human law, divine will, and animal instinct were blurred. So, as you see the judge point a stern finger at the pig, its fate sealed. You might just be glad you're a mere observer, and not the one who had to pay for its legal fees. As the judge bangs his gavel, sealing the pig's fate, you turn your attention away from the bizarre courtroom spectacle and out into the bustling, muddy streets of a medieval town. Here, a different set of strange laws governs the people, not the pigs. You're trying to blend in, to not look like you're from the future, but your simple modern clothes probably stick out like a sore thumb. Don't even think about wearing bright colors or silk. Why? Because you'd be breaking what were known as sumptuary laws. These were laws designed to regulate consumption and, more importantly, to reinforce social hierarchy. They dictated who could wear what, and what materials they could wear it with. It was all about keeping people in their place. And if you happened to be a wealthy peasant, with more gold coins than sense, you couldn't just go out and buy a fancy fur-trimmed cloak. Nope, that was reserved for the nobility. Imagine walking down the street, You pass a woman wearing a simple brown tunic, which is all she's legally allowed. Then you see a merchant, slightly higher up the food chain, who might be permitted to wear a little bit of blue or red. Then, you spot a knight, and he's decked out in a cloak of crimson velvet, a fabric so expensive and rare it practically screams, "I'm important and you are not." You notice the size of his hat, too. No, not because it's a particularly fashionable hat, but because it's probably a good foot taller than anyone else's. That's another rule. The height of a hat could be legally regulated based on your social standing. Some laws even dictated the length of a nobleman's shoe, the longer the pointed toe, the more important the guy. It was like a medieval version of a peacock display, but with legal penalties for anyone who dared to get too flashy. The motivation behind these laws was part economic and part social. On the one hand, they were an attempt to curb the extravagant spending of the new class of wealthy merchants who were starting to blur the lines between themselves and the old aristocracy. You couldn't buy your way into the upper class if the law wouldn't let you dress the part. On the other hand, it was a very public, very visible way of ensuring everyone knew their place. A glance at someone's clothes was all you needed to know if they were a noble, a knight, a merchant, or a commoner. It was a class system enforced with needles and thread, with penalties that could range from a hefty fine to public humiliation, or even imprisonment. And it wasn't just about fabrics and colors. Some laws were even more specific. One French law, for example, prohibited prostitutes from wearing veils. The idea was to make sure they were clearly distinguishable from respectable women. Another law in England dictated that you could only wear gold thread on your clothing if you were a certain rank, or if you were a knight who had recently been on a crusade. Historians still argue whether these laws were actually effective. They were widely defied, and the fashion police of the Middle Ages were probably overworked, trying to keep up with the latest trends and illegal sartorial choices. So while the laws were on the books, enforcement was often a hit-or-miss affair, with people finding clever ways to skirt the rules, like using dyes that looked like a restricted color but technically weren't, or adding small, hidden bits of illegal trim. The very idea that your clothes were not just a personal choice but a legal statement is a strange one. A far cry from the modern world where you can wear whatever you want, whenever you want. So as you continue your journey, you might just be grateful for the freedom to wear that bright red jacket. A freedom that would have been a crime not so long ago. Now you're really starting to feel the weight of this world's strange logic. You've seen animals on trial and people fined for wearing the wrong socks. What could possibly be next? Well, as you walk past the town square, you notice a massive church bell. It's not just a bell. It has a name. A plaque beneath it says, Bartholomew. And for some reason, people seem to be giving it a wide berth, whispering as they pass. You ask a nearby fruit vendor what the deal is, and he whispers back, "Oh, he's got a legal notice against him. He's on trial." A bell, on trial. This brings us to a concept that sounds like something out of a fantasy novel: the legal rights of inanimate objects. Believe it or not, in some places, objects, from church bells to rocks, were considered to have a form of legal standing. The bell you're looking at, Bartholomew, has a long and storied history. A few years back, it fell and injured a man, and the family of the injured man sued the bell itself. Not the bell maker, not the church, but the bell. The idea was that the object, having caused harm, was somehow legally responsible. In this case, the bell's case was brought before a court. A lawyer was appointed to represent it, and after a trial, it was found innocent. Why? Because the court ruled that the rope holding it had frayed, and the rope, not the bell, was to blame. So, Bartholomew was pardoned and returned to its rightful place. The rope, however, was likely cut up and thrown in the fire. This might sound like the most ridiculous thing you've ever heard, but it actually stems from the same kind of thinking as the animal trials. The medieval mind was not always a black and white, logical one. It often blurred the lines between the living and non-living, the human and the divine. An object that caused a death or injury could be seen as having malice or being under a curse. To cleanse it of its sin, or to extract justice, it had to be put on trial. This legal fiction was a way of making sense of tragedy and asserting a human claim to justice, even when the perpetrator was a lifeless piece of metal or stone. A particularly fringe tidbit is the case of a massive rock in a small French village. It was a well-known landmark. But one day it rolled down a hill and crushed a passing cart. The rock, in a show of what I can only imagine was a slow and plotting defense, was put on trial. The prosecution argued that it had, maliciously, left its position. The defense argued that it had been moved by a natural event, a landslide. The rock was found guilty and sentenced to be broken up into gravel, which was then used to repair the very road it had blocked. A stone's throw from justice, I suppose. Historians still argue whether these trials were purely a way to address a legal void, since you couldn't punish a person for a truly accidental death, or whether they were part of a deeper cultural belief in the animate nature of the world. It's a concept that's hard to wrap your head around, but it was a very real part of their legal system. So, as you walk past Bartholomew the Bell, you might just give it a nod of respect. After all, it's a fellow traveler, a fellow citizen of this strange, legally fraught world. Just don't get too close. You never know when it might decide to sue you for loitering. Now that you've managed to avoid a lawsuit from a bell, you continue your stroll through the town, keeping your head down, but you can't help but notice the hushed whispers and pointed fingers as a woman rushes past with her face completely hidden by a long hood. You lean in to ask your new acquaintance, the fruit vendor, what's going on? Oh, he says, that's Margaret, her punishment for slander. She's not allowed to show her face for a month in public. And it's a generous sentence. Believe me, her neighbor could have had her tongue cut out for what she said. This is your introduction to the harsh and sometimes comically specific laws of medieval slander and gossip. In a society where reputation was everything, your good name was a fragile thing, and the legal system worked hard to protect it. Slander wasn't just a social faux pas, it was a criminal offense with serious consequences. The laws were particularly harsh on women, who were often seen as the primary culprits of gossip and malicious rumor spreading. The punishments were as creative as they were cruel. One of the most common was the scold's bridle, or brank, an iron muzzle that fit over the head and often had a spike that would press down on the tongue if the wearer tried to speak. The woman would then be led through the town, a public spectacle of shame and silence. It's a bit much for just saying that your neighbor's chickens are a bit scrawny, isn't it? The legal definition of slander was much broader than it is today. It wasn't just about false statements that caused financial damage. It could be any statement that damaged a person's honor or reputation. Calling someone a thief, a liar, or even just questioning their piety could land you in serious legal trouble. There were even specific punishments for specific insults. If you called a woman a whore, you might be forced to stand in a public square with a sign around your neck proclaiming your offense. The public nature of these punishments was a key part of the deterrent. The shame and humiliation were meant to be a lesson, not just for the offender but for everyone else watching. A particularly quirky tidbit from this era is the legal concept of the gossip bench. This was an actual piece of furniture, often in the town square, where people who had been convicted of spreading rumors were forced to sit for a day, exposed to the scorn and mockery of their neighbors. It was an all-day spectacle of shaming. A medieval version of being ratioed online, but with real-world consequences and no option to log off. Historians still argue whether these laws were an effective way to keep civil order, or if they were primarily used by the powerful to silence dissent and control the narratives about them. The line between a legitimate legal action and a personal vendetta was often very blurry, and a well-connected person could use the law to ruin a social rival with a few well-placed accusations. So, as you see Margaret hurry past, you might just be glad that the worst a false tweet can do to you is get you cancelled. Not fitted for an iron muzzle. Having navigated the treacherous waters of medieval gossip, you find yourself feeling a little peckish. You spot a vendor selling what looks like a succulent roast duck. How much for a leg, you ask? He shakes his head sadly. I can't sell you that. Sir, it's Tuesday. No meat on Tuesday. You're baffled. This is a perfect example of the peculiar food laws that governed medieval life. They weren't just about what you could eat, but when, where, and even how. These laws were a strange mix of religious mandates, social control, and economic protectionism. They were designed to maintain social order and, in some cases, to protect local industries. For instance, the law about no meat on Tuesdays likely stems from religious fast days, a common observance in the Christian calendar. though the specific rules varied widely. Lent, of course, was the big one, a period of 40 days where meat was forbidden. But there were many other smaller fast days throughout the year, and they were legally enforced. Breaking a fast wasn't just a sin, it was a crime. You could be fined, or worse, publicly shamed for your indulgence. The funny part is that some foods were legally classified in a way that would make a modern biologist scratch their head. For example, beavers were considered fish, so you could eat beaver on a fast day. And some people tried to argue that puffins were fish, too, because they lived by the sea. They were trying to loophole their way to a nice, fatty meal. It's a bit of a stretch, but you have to admire their creativity. Beyond religious rules, there were laws that tried to regulate the market. In many towns, a law dictated that you could only sell bread on certain days or in a specific place. And the size and price of the loaf were also regulated by law. A baker who sold a loaf that was too small for the regulated price could be fined or even put in the stocks. This was a form of consumer protection, meant to ensure fair prices and prevent merchants from taking advantage of people. A classic mainstream historical fact is the assize of bread and ale in England, a law that meticulously controlled the weight, quality, and price of bread. It was one of the most important pieces of food legislation of the Middle Ages. A particularly absurd tidbit is the French law from the 14th century that prohibited peasants from eating the legs of frogs. They were reserved for the nobility. It's hard to imagine anyone enforcing such a law, but it shows the level of detail these rules could get into. They were meant to draw a clear line between the classes, to ensure that even the most humble of meals reflected one's social standing. Historians still argue whether these food laws were genuinely about piety and fairness, or if they were just another tool for the powerful to exert control over the lives of the lower classes. It was probably a little of both. So, as you walk past the vendors, you might just be glad that the only law you have to worry about is whether or not you have enough cash for a decent bite to eat. Leaving the tantalizing smell of forbidden food behind you, you find yourself on the outskirts of the town, at the edge of a massive, dark forest. A sign warns you in no uncertain terms, the King's Forest. Trespassers will be punished. The forest looks inviting, a quiet respite from the crowded, smelly streets, but you wisely keep your distance. This forest, you see, is not just a bunch of trees. It is governed by some of the most brutal and unforgiving forest laws of the Middle Ages. These laws were designed to protect the royal hunting grounds and were a powerful symbol of aristocratic privilege. While the average person was starving, the king and his nobles had a massive private park full of animals for their sport. The core of these laws was simple: the forest and all the game within it belonged to the monarch. Anyone who entered without permission, or, worse, dared to hunt an animal, was in for a world of pain. A mainstream historical fact is that in England, following the Norman conquest, William the Conqueror established a particularly harsh set of forest laws. The penalty for killing a single deer, for example, was not a simple fine. It could be a blinding, a maiming, or even death. The law was not just about protecting the animals. It was a way of reinforcing the king's power and controlling a valuable resource. It was a clear message that the life of a deer was more valuable than the well-being of a commoner. But the laws went beyond just hunting. You could be punished for even small acts, like collecting firewood or gathering nuts. Imagine you're just trying to get some kindling for your fire, and you're legally considered a criminal. It's insane. These laws were enforced by special foresters, who were often even more feared than regular law enforcement. They had a reputation for being ruthless and had the authority to mete out justice on the spot. It was a very effective way to keep the poor out of the king's pantry. A quirky, lesser-known tidbit is the concept of pannage. This was a special legal right to let pigs forage in the forest. It was a significant source of food for many peasants, but you had to pay a fee to the lord for the privilege. Without it, you were breaking the law and risking everything. The amount of the fee was often based on the number of pigs you had, and the dates for pannage were strictly controlled, usually in the autumn when the acorns were falling. Historians still argue whether these laws were an effective way to manage the land, or if they were simply another way to oppress the lower classes and maintain a monopoly on power. The forests were a source of food, wood, and shelter, and by controlling them, the king controlled a fundamental part of his subjects' lives. So as you stand at the edge of the woods, remember that while you may be tired and hungry, the trees and the beasts within them are legally off limits, and the punishment for a hungry stomach is a legal reckoning. You retreat from the ominous forest and head back towards the town square. A much safer place to be, despite the risk of slander and food fines. As you meander through the crowds, a particularly boisterous character catches your eye. He's dressed in a bright, motley tunic, bells jingling on his cap, and he's telling a joke to a small crowd, poking fun at the local lord. The crowd roars with laughter. You're amazed. The man you saw in the last section would have had his tongue cut out for less. You ask a nearby vendor about him. "Oh, that's the jester," she says. "He can say whatever he wants. It's illegal, right?" You've stumbled upon the peculiar legal status of jesters. In a world of rigid social hierarchies and harsh laws, the jester, or court fool, occupied a unique and legally protected position. A mainstream historical fact is that the jester was one of the few people in court who could openly criticize the king or the nobility without fear of severe reprisal. Their role was not just to tell jokes but to offer a form of social commentary and, in some cases, to be a trusted advisor. Their legal immunity was a crucial part of their job. By making the criticism into a joke, they could deliver an uncomfortable truth in a palatable way. Think of them as the medieval equivalent of a late-night talk show host, but with much more direct access to the most powerful person in the land. But this freedom was a double-edged sword. While they were legally exempt from many of the laws that governed ordinary people, they still walked a very fine line. A jester's success depended entirely on his or her ability to read the room and know exactly how far they could push a joke. A joke that landed well could win them favor and even influence policy. A joke that landed badly, however, could be the end of their career, or even their life, if the joke was perceived as treasonous or overly personal. The jester's immunity wasn't a universal get-out-of-jail-free card. It was a privilege granted by the monarch and could be revoked at any time. A quirky and fringe tidbit is that some jesters were so successful that they were granted lands, titles, and even their own legal exemptions. The most famous example is possibly Tribalent, the jester for King Francis I of France, who was given a legal immunity so strong that he was a sort of royal wildcard. He once told a joke that the king found offensive, and the king, in a fit of rage, threatened to hang him. Tribalent, with his typical wit, said, "Please, hang me 24 hours after the King of France." The king, delighted with the witty and technically impossible response, forgave him. Historians still argue whether the jester's legal status was a genuine recognition of their unique role, or if it was simply a form of social release valve, a way for the powerful to let off steam by allowing a sanctioned form of mockery. It's probably a bit of both. So as you see the jester perform, you can't help but admire his courage. But you're also reminded that even his freedom is a fragile thing, dependent on the whim of a powerful few. As the jester's laughter fades, you can't help but notice a procession making its way down the narrow street. It's a funeral procession, but it's not what you'd expect. The mourners are few, dressed in simple robes, and the coffin is being carried on a plain wooden cart, not a grand hearse. You ask the same vendor why the funeral is so modest, and she shakes her head. The family was fined, she says. Too many people. They broke the law. You've just witnessed a direct consequence of the strange laws governing death and burial in the Middle Ages. These laws were a mix of sumptuary rules and public health regulations, and they were often as bizarre as the laws on food and clothing. A mainstream historical fact is that many medieval cities and towns had laws that regulated the size of funeral processions. The purpose of these laws was twofold. First, they were a form of social control. Like the sumptuary laws you've already encountered, a rich family couldn't just throw a massive, extravagant funeral that would make the poor feel even poorer. These laws were an attempt to keep class distinctions clear and to prevent the kind of conspicuous consumption that could lead to social unrest. The size of the procession, the number of candles, and even the type of coffin were all subject to legal scrutiny. The penalty for overdoing it could be a hefty fine, which would have been a bitter pill to swallow for a grieving family. The second reason for these laws was more practical, though no less strange: to limit the spread of disease. A large gathering of people, especially around a corpse, was a public health hazard. in an era before modern medicine and a clear understanding of germ theory. Controlling these gatherings was a logical, if blunt, way to limit the spread of plague and other illnesses. But the laws went beyond just the size of the procession. A quirky, lesser-known tidbit is that in some cities, laws dictated the specific time of day a funeral could be held. Many towns only allowed funerals after dark, or in the very early hours of the morning, to further limit public gatherings and keep the streets clear during the busiest times of the day. Another fascinating element was the law surrounding where you could be buried. For a commoner, burial in consecrated ground, usually a church graveyard, was a matter of course. But for someone who had committed a crime, or for an unbaptized infant, burial in the graveyard was forbidden. Their bodies were often dumped in an unmarked grave outside the town walls. A final act of legal condemnation that followed them even in death. Historians still argue whether these laws were an effective way to control social order and disease, or if they were simply another way for the church and the state to exert control over the lives and deaths of their subjects. In a world where the afterlife was as real as the present, these laws were a powerful tool for social control. So as you see the simple funeral cart disappear down the street, you can't help but think about how even in death, a person's life was still governed by a set of strange and sometimes cruel laws. The somber funeral procession has disappeared, but your journey through this strange legal landscape is far from over. You find yourself in the town square again, where a different kind of spectacle is about to unfold. Two men stand before a judge. One is accused of theft, and he pleads his innocence. The judge, in a grave tone, doesn't ask for witnesses or evidence. Instead, he orders the man to walk across a line of hot iron rods. The accused looks terrified, and you can see why. This is a trial by ordeal, a cornerstone of medieval justice, and it's built on a logic that feels alien to the modern mind. The idea behind the ordeal was that God was the ultimate arbiter of justice. A legal case that couldn't be settled by human testimony or evidence would be turned over to divine judgment. The accused would be subjected to a dangerous or painful task, and their fate was literally in the hands of a higher power. A mainstream historical fact is that the most common forms of ordeal were the ordeal by hot iron and the ordeal by water. In the ordeal by hot iron, the accused would have to carry a red-hot piece of iron a certain distance. If their hand healed cleanly after a few days, they were considered innocent. If it didn't, they were guilty. I can't help but think that a person's guilt or innocence had a lot to do with the doctor who was treating them. But I digress. The ordeal by water was a bit different. The accused would be tied up and thrown into a body of water that had been consecrated. If they sank, they were considered innocent, because the pure water had accepted them. If they floated, they were guilty, because the water had rejected them. A clear sign of their sin. The logic is a little confusing, isn't it? It sounds like the legal system was punishing the guilty with a bit of a dry dunking, but the innocent with drowning. It's a bit of a grim punchline. A quirky, lesser-known tidbit is that the clergy were forbidden from participating in these ordeals after 1215 when Pope Innocent III declared them unlawful. This was a major turning point, and it began the slow decline of the practice, leading to the rise of jury trials and more evidence-based legal systems. The Pope's decision was a big deal, and it showed a shift in thinking, from a purely divine justice system to one that relied more on human reason and a jury of one's peers. Historians still argue whether the ordeal was a genuinely believed form of justice or if it was simply a way to force confessions. The threat of a hot iron or a watery grave was a powerful incentive to admit your crime. So as you watch the man with the hot iron, you can't help but think about how far we've come, and how grateful you are for a legal system that, while imperfect, at least doesn't involve divine intervention and a second-degree burn. With the ordeal concluded, you find yourself leaving the town square, pondering the strange legal system you've just witnessed. The concept of marriage, you think, must be free from such bizarre rules. Surely, love is a matter of the heart, not the law. You'd be wrong. Medieval Europe had some truly odd laws of love and marriage. They weren't about romance, they were about property, social standing, and political alliances. A marriage was a legal contract, and the law was deeply involved in every aspect of it. A mainstream historical fact is that arranged marriages were the norm, especially among the nobility. A noblewoman's hand in marriage was a political asset, a way to secure alliances, expand landholdings, or consolidate power. The woman had little to no say in the matter, and the contract was often drawn up when the couple was still in childhood. The legal system enforced these agreements with an iron fist. Refusing to marry a chosen partner could result in legal and social ruin for a family. In some cases, a woman who refused to marry could be legally disinherited or even cloistered in a convent. It was a legal obligation, not a romantic choice, but the laws went deeper than just arranged marriages. A quirky and fringe tidbit is the practice of handfasting. In some places, particularly in Scotland and Ireland, handfasting was a form of temporary, or trial, marriage. The couple would live together for a year and a day, and if they decided the arrangement didn't work out, they could legally separate without any penalty. It was a sort of legal, try before you buy, for marriage. And it was a practical way to deal with the reality that not all arranged marriages worked out. This practice was in stark contrast to the Church's view of marriage, which was that it was a sacrament, permanent and indissoluble. Another strange law was the legal fiction of forced marriage. A couple could be considered legally married even if they didn't have a formal ceremony, as long as they had a public agreement to marry and had sex. This created all sorts of legal problems, from accidental marriages to people trying to get out of a commitment by claiming they never, formally, consented. Historians still argue whether the laws surrounding marriage were a way to keep families in line, a way to protect property, or a way to ensure the continuation of the lineage. It was likely all three. So, as you see a young couple holding hands, you can't help but wonder if their love is a true choice, or if it's a legal arrangement with a dowry contract tucked away in a dusty legal book somewhere. Leaving the bizarre laws of marriage behind you, you find yourself at the entrance to a bustling market. The air is thick with the smell of fresh bread, tanned leather, and hammered metal. But as you watch a blacksmith at work, you notice a man in a black tunic, holding a clipboard, meticulously inspecting the size and shape of the horseshoes being made. He's an inspector from the local guild, and his presence is a reminder that even the simplest acts of commerce were governed by a thick web of strange and often contradictory laws. The medieval guilds were more than just trade unions. They were powerful institutions that controlled every aspect of a particular craft. They were a legal and social force, and they had a set of rules that would make a modern bureaucracy blush. A mainstream historical fact is that the guilds set strict rules for their members. They dictated the price of goods, the quality of materials, the number of hours an apprentice had to work, and the exact steps a craftsman had to take to become a master. Breaking a guild rule wasn't just a social faux pas, it was a legal offense with serious consequences. You could be fined, banned from practicing your trade, or in some extreme cases, expelled from the town. The laws were designed to protect the industry from outside competition and to maintain a high standard of quality. A quirky, lesser-known tidbit is the concept of the guild secret. Many guilds had a secret recipe or technique that was a closely guarded legal secret, passed down from master to apprentice. For example, the recipe for a particular type of dye, or a specific method for smelting iron, was considered a form of legal property. Sharing that secret with a non-member was a serious crime, and the punishment could be severe. It was a form of intellectual property law, but with legal penalties that included being blackballed from the trade for life. This was a very effective way to keep the knowledge and the profits within the guild. Historians still argue whether these guilds were a force for good or evil. On the one hand, they ensured quality and stability. You could be sure that a guild-stamped product was well made and fairly priced. On the other hand, they were a monopoly that stifled innovation and made it incredibly difficult for a newcomer to break into the market. They were a sort of legal cartel, using their power to maintain control over their industry. So as you see the inspector from the guild walk away, his job done for the day, you can't help but think about how every single object in that market, from a loaf of bread to a leather boot, was created under a set of laws so strict they would be unthinkable today. As the guild inspector disappears, you find yourself wandering toward a small, secluded house on the edge of town. A crowd has gathered, but there is no festive atmosphere. A man is being led out, his hands bound, and his face is a mask of terror. A woman points at him, her voice filled with venom. He's a sorcerer. He put a curse on my cow. This is your introduction to the terrifying laws on witchcraft and magical thinking, which were a very real and very dangerous part of medieval life. In a world where science was limited and superstition was rampant, the line between an illness and a curse, between a natural disaster and a malevolent spell, was incredibly blurred. The legal system, especially later in the Middle Ages and into the Renaissance, became a powerful tool to prosecute what were considered spiritual crimes. A mainstream historical fact is that the persecution of witches was codified in legal texts, most notably the Malleus Maleficarum, or Hammer of Witches, which was a legal and religious treatise that provided a detailed guide on how to identify, prosecute, and punish witches. It was not just a book of folk tales, it was a legal instrument that was used in courts all over Europe. The legal process was often a farce. Evidence could be as flimsy as a neighbor's accusation or the fact that a person had a strange birthmark. Torture was often used to extract confessions, and once a person confessed, they were almost certainly going to be executed. The law was not designed to find the truth, it was designed to justify a preconceived notion of guilt. The penalty for witchcraft was almost always death, usually by burning at the stake, as it was believed that fire would cleanse the soul of its demonic taint. A quirky, lesser-known tidbit is the concept of a toad trial. In some regions, a person accused of witchcraft would have a toad brought into the courtroom. The toad was believed to be the witch's familiar spirit, and if it acted strangely in the presence of the accused, it was considered legal proof of their guilt. Imagine a legal system where the testimony of a toad was considered a legitimate piece of evidence. Historians still argue whether the witch hunts were a result of genuine fear, a way to deal with social outcasts, or a way for the powerful to consolidate their power by creating a common enemy. It was likely a bit of all three, with religious fervor, social anxiety, and political opportunism all playing a role. So as you see the accused man being led away, you can't help but be struck by the fact that in this world, an accusation was often all it took to seal a person's fate. And the law was a tool for fear, not justice. Leaving the scene of the alleged witchcraft behind you, you find yourself on a dirt road, where a tragic scene has just unfolded. A farmer's cart, overloaded with hay, has lost a wheel, and the cart has toppled, crushing the farmer's young son. The air is thick with grief and the smell of fresh-cut hay. A local lord, who happens to be riding by, stops. Instead of offering comfort, he declares, "The cart is now the property of the crown." The family looks on in stunned silence. This is your introduction to a concept that sounds completely illogical to a modern ear: the legal fiction of deodand. The word deodand comes from the Latin phrase deodandum, which means to be given to God. The concept was a legal rule that said if a movable object, a cart, a sword, a cow, was the direct cause of a person's death, that object was forfeited and given to the church or the crown. The idea was that the object was accursed or tainted by the death it caused, and that the only way to cleanse it was to use its value for a holy purpose. A mainstream historical fact is that the value of the deodand was often used to pay for masses for the dead person's soul or to provide for their family. But the final decision of how the money was used was up to the local lord or the crown. The object itself was often sold, and the money was handed over. The deodand was a strange mix of religious superstition and a form of compensation. On the one hand, it was a way of making sense of a senseless death, by assigning legal blame to the object that caused it. On the other hand, it was a useful tool for the powerful. Imagine a wealthy merchant's horse that throws a rider to their death. The horse, a valuable piece of property, could be legally claimed by the crown as a deodand. It was a way for the powerful to seize valuable assets, all under the guise of religious or legal necessity. A quirky and fringe tidbit is that the law of deodand was so specific that it even applied to things that were not directly used in the death. For example, if a person fell off a bridge and was killed by the impact with the water below, the bridge was not considered a deodand. But if the person was killed by a cart on the bridge, the cart was a deodand. If a person was killed by a falling bell, remember Bartholomew? The bell would be a deodand. The logic was that only a movable object could be a deodand. Historians still argue whether the law of deodand was a genuine religious belief or a convenient legal fiction for seizing property. It was probably a little of both. The idea that an object, a lifeless thing, could be legally punished for a death it caused is a powerful reminder of the strange and sometimes cruel logic of the medieval legal system. The dust of the deodand incident has settled, and you find yourself in the bustling heart of the town. You're hot and tired, and the thought of a good bath sounds heavenly. You spot a building with a sign that says, "Public Baths," and you head toward it with a sense of relief. But as you get closer, you see a line of people waiting to get in, and a legal official is at the door, meticulously checking a document from each person. What could this be? You've stumbled upon the curious laws about public bathing. In a world without modern sanitation, public baths were a popular and necessary part of life. They were social hubs, places to gossip, and even places to conduct business. But they were also governed by some very strange laws. A mainstream historical fact is that many towns and cities had strict laws about the hours of operation and the days when men and women could use the baths. In many places, the baths were segregated, with separate times for men and women to bathe. But in other places, they were communal, and this led to a set of laws that tried to regulate the behavior of the bathers. The problem, from a legal perspective, was that the communal baths were seen as a hotbed of immorality. Gossip, illicit affairs, and even gambling were all said to take place in the baths. As a result, the law stepped in. A quirky, lesser-known tidbit is that in some cities, a law dictated that you could not wear a hat in the bath, as it was a sign of a gentleman, and you were expected to be naked and equal in the bath. This was a strange attempt at social egalitarianism, a legal rule that tried to strip away the social hierarchy for a few hours. Another rule in some places was that you could only bring a certain amount of money with you to the baths. To prevent gambling, it was an attempt to keep the baths a place of health and cleanliness, not a den of iniquity. Historians still argue whether the laws about public baths were a genuine attempt at social and moral control or a way for the authorities to make money from fines and taxes on the bathhouses. The baths were a cash cow, and the laws were a way to get a slice of the pie. So as you wait in line, you might just be grateful that your desire for a hot bath is not subject to a set of rules that could land you in legal trouble. You've made it past the bathhouse laws, but as you walk down the street, you're hit with an overwhelming, frankly disgusting, stench. You look down and see, well, you see things you probably don't want to see. The street is a sewer, a repository for all manner of human and animal waste. This is your final stop on this weird legal tour, the strange laws of sanitation. Or, more accurately, the lack thereof. In a world with no modern plumbing, what you did with your bodily waste was a legal matter. And it was a surprisingly specific one. A mainstream historical fact is that many medieval cities had laws against throwing your waste out the window. But they were almost universally ignored. The French city of Paris, for example, had a law in the 14th century that required people to shout, "Garde à l'eau," or "Look out for the water," before tossing the contents of their chamber pots onto the street below. This was a legal requirement, a way to give a passerby a chance to dodge the contents of your midnight snack. It's an insane law, isn't it? It basically says, you can still do this disgusting thing, but you have to give people a warning first. The punishment for not shouting was a fine, but it was rarely enforced, and a great deal of the street-level filth was the result of people just not caring about the law. Another quirky, lesser-known tidbit is the concept of a gong farmer or a gong scourer. These were legally recognized occupations, and their job was to clean out the cesspits and latrines of the city. The law dictated that they could only work at night, and they were often legally required to live in a designated area of town, away from respectable citizens. Their job was so low on the social ladder that they were almost outside of the legal system. With their own set of rules and punishments for misdeeds, they were necessary for the health of the city, but they were also a legal and social pariah. Historians still argue whether the lack of sanitation laws was a result of a lack of knowledge about disease, or if it was simply a reflection of the social norms of the time. It was likely a bit of both. The idea that you could be fined for not shouting, "Look out," before you toss your slop out the window is a fitting final image for this strange journey. The sun is setting now, casting long shadows over the filthy, Legally fraught streets. The smells of the city are fading into the cool evening air. And the sounds are starting to soften. The world you've been exploring, with its strange laws about animals and food and clothes and everything else, is starting to feel a little less real. A little more like a distant dream. The pig in court, the woman with the iron muzzle, the hot iron ordeal, and the deodorant cart. They're all fading into a jumble of strange images. It's time to let them go. The journey is over, and your mind is starting to wander. The sounds of the medieval town are softening now. The last bell from the church tower rings out. A single, clear note. The street is quieting. The last voices are fading. And you are starting to feel a profound sense of peace. The day is done. The world is quiet. And the only laws you have to worry about are the ones that govern sleep.